Good evening. My name is Evita Mahanti and I've studied law. I did my bachelor's and master's from Madhusudhan Law College under Utkal University, and I'll be giving a brief introduction on Code of Criminal Procedure, which has been repealed and replaced by Bharatiya Nagarik Suraksha Samhita 2023. Thank you. Now, before getting into the detailed provisions or the important provisions of CRPC, which is the contemporary is being BNSS Bharatiya Nagarik Suraksha Samhita, I'll be mentioning code for now. And before explaining the provisions, I would like to give you an explanation as to what does CRPC applies to, or what is its ambit, why it is called as a code. There are enactments made by Parliament which we call Act. There is Consumer Protection Act, the Sales of Goods Act, there's varieties of acts that Parliament or state legislature passes, and it has effect on certain particular rights or certain particular issues of people. But when we talk about codes are consolidation or gathering of rules, procedures, practices under one heading, which will be in relation to a particular part of law, and it will deal with that certain particular area. So, Code of Criminal Procedure is basically a set of procedural provisions which guides us as to how the law will be implemented, and when I say law, how IPC will be implemented. Suppose section 4 of the act, both in section 4 of the code, both in the code and the Samhita, section 4 gives us an ambit as to what CRPC or the Samhita applies to. When we say that any investigation, inquiry, trial or other proceeding with regards to any offence mentioned in IPC, it will be dealt according to the procedure which is provided under the code or the Samhita. Now, if there is any other independent act which creates or punishes an act to be an offence, if that particular act does not provide a provision of procedure, then CRPC will also apply to that offence. And the section 4 deals with that. It provides a sets an ambit as to what exactly CRPC will apply to. Now, there comes a question that if offences mentioned in IPC will be the procedure will be decided by CRPC, then CRPC came in the year 1973, but IPC was always there since 1860. So was there a big gap? Was there no procedure at all to set how the offences would be tried or investigated or looked upon? No, that was not the case. When we say IPC 1860, after IPC came into force in 1860, in 1861, a criminal procedure code, we can say, came into force. After 61, there were many changes in following years like 71, 82, 98, 1923. In 1955 and 1958, so much I remember, the 14th law report suggested or recommended various of changes, various of alterations to be brought in the criminal legal system, and those were implemented, and Criminal Procedure Code 1973 came into force, and it repealed and replaced the Code of Criminal Procedure 1898. So this is how the journey of CRPC has been, and now it has been repealed and replaced by Bharatiya Nagarik Suraksha Samhita. Now the next question that comes to my mind is whether CRPC or the Samhita is a complete procedural act or procedural code, or it is a combination of adjective and subjective law. Various times we have a understanding of what a procedural law is. Procedural law basically means which sets out a procedure, how it is to be done, the manner in which it is to be conducted, and subjective law deals with rights and claims of a person. And clearly, we always have an idea that CRPC or the Samhita is an adjective law, but that's not the case. CRPC, or the Sanhita which we are dealing right now, is a combination of adjective law and subjective law. The reason being, CRPC does not just lay the procedure how an investigation to be conducted, how a trial to be conducted, how inquiries is to be done, how evidence is to be appreciated, but it also provides in certain areas, like there are chapters 8, chapter 9, 10 and 11, which deals with the right to maintenance of a person, which deals with the right of a person who has been asked to to give security for good behavior and to keep peace. Certain preventive actions are also laid down in the code to prevent the commission of offense in order to save rights. So there are certain areas which deals with the subjective part of the law. So we cannot say it is exclusively an objective law. And so this is the basic criteria of what criminal procedure is all about. Now, there are certain provisions, very important provisions. There are almost 500 something. There is all of in the new code, the new Sanhita, there are more than 500 provisions, I believe. I have not gone through the code very well, but going through the important provisions and understanding the difference between the old act and new act, I have figured out there are more provisions, but I'll try to explain the code, the important provisions to you through an example. I'll give you an illustration and I'll try to connect the illustration with each and every important provision of the CRPC, trying to create a link between each one of them. And concluding the case will conclude my brief introduction of the CRPC. Now suppose I'll give you an example. There are 3 people, A, B and C. A beats B to an extent that he cannot just stand on his own 2 legs. He beats him, he thrashes him, he fractures his hand, he keeps on beating in a public place and there are people to see and see one of the witness. And that's scenario 1. He just beats him to an extent that he causes so much body pain, the doctor prescribes him that you cannot get up from your bed for at least a month now. Now in scenario number 2, the same thing happens, but he uses a knife. He causes multiple cuts. If he was lucky enough, he could have just stuck the knife in his stomach and B might have died. It would have been that situation. So in these both 2 situations, facts are almost same. And in first case, it was just simple bruises, but it's lot of beating, lot of bodily pain, which prevents B from having his daily pursuits for at least a month, which doctor prescribed. He cannot get up from his bed. And in the next scenario, the similar case, but there has been a weapon used, which is a sharp knife, which has potential of causing death, and it was used with that intention also. So similar matter, similar case, but 2 different scenarios. Now, C is a witness along all the other people who saw A beating B. C was one of them. C found it very unreasonable and went to a police station. C went on to the police station and said the police officer in charge that I have seen an incident like this where I saw A beating B so ruthlessly that he's unable to stand on his own 2 legs. The police, understanding the whole scenario at hand, realizes that the offences that C is saying A has committed is cognizable ones. And in multiple of cases in Supreme Court, we have realized that in case of cognizable offence, it is sine qua non, it is important, it is mandatory for the police officer to register an FIR. Now, in Lalita Kumari case, we have also realized the same. Also in Bhajan Lal case, we have realized that refusal of taking in FIR is a dereliction of duties, a major dereliction. So when the police officer is aware that there is a commission of cognizable offence, it becomes mandatory on part of the police officer to register an FIR. Now the question is, why do we have the need to go and let the police know about it? Because criminal law is always stagnant. It gets in motion by two procedures: by filing an FIR or making a complaint to a magistrate. Because there are many cases happening all over the world all the time, but criminal law sets in motion only when there's an FIR made to a police officer or a complaint made to a magistrate. Now once he tells the police officer that a offense amounting to a cognizable one has been committed, it is the duty of the police officer to register an FIR. Now, FIR has been registered, criminal law has been set in motion. Next what? Criminal Procedure Code, or the Sanhita presently, tells us what happens after what. After this case, considering those two scenarios, whatever be the situation, the FIR has been filed. Now, in case of cognizable FIR, cognizable offense, we continuously use the term cognizable. The term means that any offense is said to be cognizable according to the Schedule 1 of the Sanhita. We will realize that the police officer has power to arrest the person who has done the offense without a warrant or the order of the magistrate or court. So, in case of cognizable offense, police officer has boundaryless power to arrest a person who is committing the offense. Now that's the meaning of cognizable offense. So when the cognizable offense has been registered, so CRPC or the Sanhita also provides the procedure how the FIR is to be registered, what are the things to be done in order to make a valid FIR, and what happens if he doesn't accept the FIR or if he refuses to register an FIR. Those things are also mentioned, but I'll not go into that area. I'll just try to give you a clear picture what happens after the other. Now after the FIR is registered, in the code under section 157, which is probably 175 of the Sanhita, it tells us or gives us an idea that police officer will have to forthwith, immediately write a report to the magistrate who has power to take cognizance. Cognizance means application of judicial mind, who has the power to apply his judicial mind. Police officer will write immediately forthwith write a report to him and immediately proceed to the spot for investigation. He will investigate the facts and circumstances of the case. He will make due discovery, whatever needed, and also has the power to make an arrest. Suppose after getting the information, he immediately does the due thing and he proceeds to investigate, and upon investigating, he has a bunch of power, like while investigating, he can take statements of witness, he can search places, he can search for the weapon if he feels like it's 165 CRPC. He can take statements under 161. He has all the power in his hand in order to ascertain whether there has been a cognizable offense committed or not, and meanwhile he has also the power to arrest the person. Suppose he finds A and he arrests him, then what? Does the criminal law is at rest now? No. After the person gets arrested, section 56 of the CRPC tells us that once he is arrested, he will be taken to the police station or the magistrate. Within 24 hours, if the investigation is not completed, the police officer forwards the accused person before the magistrate. Now, what is the need for the police officer to forward, or we call it forwarding the accused or court challan? These are the words we use to understand that there is a person who has been forwarded to court after being arrested for a offense that is cognizable in nature. Now, what is the need of the police officer to have to forward the accused before the magistrate? It is because Article 22 Clause 2 of Indian Constitution makes it a fundamental right. ensures, that magistrate has to ensure that the arrest is legal, and in such cases, in certain cases, he also decides the question of bail. Now, what is bail? Bail is a conditional liberty. When a person is set out free after an arrest, subject to certain conditions and subject to the final disposal of the case. That is bail for us. And when the person is forwarded to the magistrate, there are certain things he could do. One, he can either remove him to the custody, he can allow the bail. And when we say custody, that's judicial custody for us. There are two types of custody we will be knowing under the Sanhita, the CRPC. One is the judicial custody, that is forwarding, that is sending him to the jail after being forwarded. And the second one is police custody. Now, after he's been removed to the custody, the judicial custody, suppose there are chances that the investigation was not completed within 24 hours. But the police officer has to submit a report to the magistrate, because once the FIR has been registered and investigation has been initiated, there has to be a report that has to be submitted to the magistrate. Now, in order to complete the report, the police officer need to know all the facts and circumstances of the case and to have to make a case out of it. Suppose it cannot be done within 24 hours. What's next? He will apply to the magistrate who has power to take cognizance of the case, that the police officer is intending to take the person under police custody in order to investigate, for further investigation. And we famously call that poochtach. And for that, the police officer have to apply to the magistrate, and if the magistrate allows, there is a period of exactly 15 days where the magistrate can allow for police custody, and within that time the police officer has ample of opportunity to extract whatever statements to ensure whatever he has with regards to the case, and to make a report out of it. After the investigation is completed, the police officer submits a report to the magistrate. Now, there's again bifurcations here. When we talk about CRPC, there are bifurcations all over. One thing leading to multiple of options. So when the police officer makes a report, it could either be a final report, it could either be a charge sheet. When we call a police report a charge sheet, it means it has conclusively stated the commission of the cognizable offence and to some extent establishing the guilt of the accused. And when we call it a final report, it means there's no such mention of it, either there's been no commission of the offence at all, or the accused person is nowhere to be mentioned in the offence that has been committed. So that is the final report. And when police officer, and it is exclusive to the IO or the police officer who is investigating, has to file the police report before the magistrate, and along with the police report, all the relevant documents like that is mentioned under 173 CRPC, and I'm forgetting the exact provision in the Sanhita, but it was 173 of CRPC, which deals with the police report, and the police finally submits a report. But we have to understand that once the final report has been submitted, that is not the end of investigation. It could be a point where police can be further directed to make further investigation, or the investigation does not complete. It is to some extent, ideally it is the conclusion of the investigation, but it's not the end of it. There is a scope. If the magistrate, if the court further directs, there could be further investigation on the same matter, and subsequent reports can be submitted on the same offence. Now, in the two scenario which we should not forget, in that case, if we realize that the police officer has filed a charge sheet giving an idea that yes, A was certainly involved in beating B so badly that he is bedridden. In that case, and using weapons, supposedly in situation 2, where he used knife to cause multiple cuts on B's body. A has done that, and the charge sheet mentions it clearly. Then um, the offense that has been established here, the offense under IPC that is attracted is section 326 of IPC, which says when a committing of grievous hurt under committing of grievous hurt with dangerous weapon, and the offense is punishable with either imprisonment for life or 10 years or more. And these cases are exclusively triable by court of session. Now, if the former case of the first situation taken into consideration, he just caused him so much pain that he could not get out of his bed, there was no cut, there was no use of knife, then I think it was section 325, which says punishment for committing grievous hurt, which is I think within 7 years, and the classification of the offense says it is bailable, it is compoundable, it is cognizable in nature. And in the later case, the classification says it is it's cognizable, non-bailable, non-compoundable. These are the terms we'll understand subsequently. But once the charge sheet discloses the offense of the later case, supposedly, then what happens is, once the magistrate realizes that there is a police report before him, 190 of CRPC, I'm forgetting the provision of Sanhita, but 190 of CRPC tells us that magistrate takes cognizance on the police report. There are 3 ways magistrate can take cognizance, and magistrate always takes cognizance on the police or on the offense and not the offender. Magistrate when takes cognizance on offense, there are 3 ways he can do it: either through a police report, either through a complaint made to him, or out of his own knowledge if he realizes there's some offense going on somewhere and he has knowledge or information about it. Then 190 provides us with that. Now once the case has been taken, the magistrate takes cognizance of that offense. Now in the illustration number 2, where the cuts and bruises with the use of knife has been, after taking cognizance, he has to commit the case to the court of session. We have to understand, court of session is a court which never takes cognizance of any offense. It is always the committal court, except in certain cases as mentioned in 199 clause 2, the proviso of the 199 of CRPC, either clause 2 or the proviso, I'm forgetting right now. In certain cases like that, court of session can take cognizance of such offences, but ideally it is the general rule that court of session never takes the cognizance of any offence. It is the magistrate who does that, and it is under section 190 of the code. And court of session is a committal court. Once the charge sheet has been framed, charge sheet has been done, police report has been filed under 173, and it is a charge sheet which is disclosing actions which is amounting to cognizable offences. Then what happens? Then the case is committed. Now once the case gets committed, the case goes to the court of session for trial. Now trial begins in court of session at the stage of framing charges, and out of nowhere it doesn't start with framing of charges. While the PP or the public prosecutor opens the case, the judge examines the records, judge examines the accused and the victim, hear them, see all the relevant document it has, and applies his judicial mind and realizes whether there is sufficient ground to proceed with the trial or not. If the documents at hand, after examining the accused and the victim, he realizes that there are certain cases that there is no sufficient ground to proceed, there's no prima facie case made out here, then he can not pursue any further and he can discharge the accused. Now there's a difference between discharging the accused and acquitting him. Before the stage of framing charge, if the judge lets go the accused, then that is the discharging of the accused, and that is not acquittal. Once he has been released, once the charges has been framed, and there's nothing more to do, it is either conviction or acquittal. At that stage, after once charge has been framed, there is no coming back and there is no point of discharge. But that process is subsequent. That process leads to the series of provisions mentioned in the CRPC, which we'll deal later. Now, coming back to the important part now. So, this is what we said about the framing of charge once the charge sheet has been filed and what happens subsequently. Now, suppose there is a filing of police report, final report, which barely discloses any commission of the offence, which police officer says that nothing has happened, this person is not to be blamed, he has done nothing, this crime has not happened altogether, and after investigation he has realized that. Then does the case drops automatically? No, it does not. Despite the fact that a police officer has filed a final report not disclosing commission of any kind of offence, what he does is, when it is filed before the magistrate can accept the final report and drop the case, or takes cognizance in the final report, or asks him to take further investigation, continue it. Or if the victim or the aggrieved person is in any way not agreeing to the report filed, the final report, is not agreeing with the manner of investigation that has been done and the report that has been filed, what he can do is file a protest petition with regards to the complaint, with regards to the offence separately, and magistrate can take cognizance of the protest petition and can continue with the protest petition separately as a separate complaint case, but that's a different lookout altogether. But even if, my point is, even if the police officer files a final report, that doesn't mean the case automatically gets dropped. So we have reached a point where police officer has filed a police report. It could be either charge sheet or final report. Now, supposedly, during the investigation, we have discussed that there are chances that what if investigation could not get completed in due time within 24 hours, then what is the procedure involved? That is one mentioned already, that I have already mentioned. One of the important provision also to bring into this scenario of illustration, I want to tell you that supposedly the accused wants to admit his guilt and wants to say, meanwhile, during the investigation or any time after the investigation is completed, but before the trial begins, at that part of time, if the accused says, okay, fine, I agree, I was guilty, I have done all these acts, be it illustration 1, be it illustration 2. I have committed certain acts, and this is the manner I have done, and it is my confession. We already know in Evidence Act the confession to police officer is not a confession. It cannot be used against him. 164 of CRPC, which is probably, I'm forgetting the exact provision of the Sanhita, but 164 of CRPC tells about recording of confession. Previously, I remember previously, magistrate includes both judicial magistrate and metropolitan magistrate, but now the term metropolitan has been removed. There's no such metropolitan magistrate under the Sanhita. So a judicial magistrate can record confession of any person and who is accused of an offence, and he can record confession, he can record statements. Now there's a difference between recording confession and recording statements. In case of recording statements, magistrate can administer oath, but in case of confession, magistrate cannot administer oath. It should be voluntarily done, and before taking the confession, the magistrate has to give certain time to the accused to reflect, to come back to his normal senses, to be fine, to make him comfortable, to realize that what he's about to give is a confession, which is admission of his own guilt, and the fact that the confession which he is giving can be used against him in the court of law, and also the fact that he is giving confession should be completely voluntary. Now, once the confession has been given, or the police or the magistrate records any statement, it holds evidentiary value. We have to understand that at what stage a confession is recorded. 164 clearly says, and so is the contemporary section in the Sanhita, it says confession has to be recorded anytime during the investigation and any time after, but before the trial commences. But is confession or recording statement by magistrate is the only way statements or confession statements are recorded, which is provision of 165? Is 165 the only means of recording statement? No. 161 of CRPC, again I'm forgetting the exact provision, but 161 CRPC tells us that police officer can also ask when it takes statements of witnesses who are well aware of the facts and the circumstances of the case. Now, once the police officer asks any question to any person, he knows that he is well aware with the facts and circumstances of the case, he is bound to answer the question that has been asked, and he is bound to answer question truly, except he will avoid those questions whose answer, if he gives, will subject him to any criminal liability or forfeiture of property or penalty or any kinds of proceeding against him. Now, police officer can orally take statements from people who are potential witnesses, and can also make it in writing. But once police officer makes it in writing, reduces the statements of the witnesses in writing, he has to do it very perfectly. Each person being a witness, their statement who's been reduced to writing should be a separate true copy, true record, and it should be done as per the rules prescribed by the state government, but it has to be specifically done separately as a separate record of each witnesses giving their statement. Now, statements, confessions given to the police officer is less credible, is not always taken into consideration. Confessions though never have any evidentiary value when given to police officer, but statements, 161 statement when given has its application or its utility is only within the purview of 162. Once a statement has been given by the witness and is reduced into writing, no other way it can be used except as provided into 162 CRPC. And once the statement that has been duly proved, any statement, suppose a prosecution witness has been called, his statement he made, and that particular statement has been duly proved. I will interpret what duly proved is. Once it has been duly proved, what will happen is that particular statement can be only used for the purpose of contradiction. So the question arises, how can we know that a statement is duly proved? When we call a statement duly proved when the person given the statement has been cross-examined, or the IO who has taken the statement has undergone cross-examination. After being cross-examined and after realizing that after that phase of that trial, we realize, okay, this part of the statement or this statement for which the witness or the police officer has undergone a cross-examination, we can call it that part of the statement is duly proved. Now, statements have been recorded, confession or statements by magistrate has been recorded, final report or charge sheet has been filed, case has been committed to the session court, and suppose the moment I mentioned about bail, once the person has been forwarded to magistrate, in that point of time, one of the factors that the magistrate takes into consideration is a question of bail. Now, what is bail? I have already mentioned bail is a conditional liberty, taking into consideration some factors, and subject to the finality of the case, he is released. The person arrested is set it free for certain period of time, subject to certain conditions. And that gives us an idea. That brings us to the chapter of bail, chapter 33 of the CRPC, and in under Sahita it is I believe chapter 35, which deals with bail. Now, when the question bail comes, there are so many questions that arises. The whole chapter tells us, the whole chapter of bail tells us who can grant us bail, where the application has to be filed, bail application, to whom it is to be done, who can apply for bail, what circumstances court allows bail, or what are the mitigating factors court takes into consideration in order to grant bail. Ideally, we all know that magistrate, court of session, high court, there are multiple options, multiple forums where a bail application could be made by a person who got arrested. But there's also a factor mentioned in the bail chapter under 436 of CRPC and 437 clause 2 of CRPC, which tells us that even police officer in certain cases has the authority to grant bail. And in case, and there are, when we also say about bail, bail is a conditional liberty, and it could be bail, the offense could be of bailable nature or non-bailable nature. When we say an offense is bailable nature, and it is mentioned in the first schedule of the Code of Sanhita that certain offense is bailable in nature, as in case of our illustration number 1, which is just causing bodily pain for which he could not just get up from his bed for 20 days or for a month at least. In that case, it is a bailable form of offense, which is bail is a matter of right. It is his right, which the law provides, that he can apply for bail. If he's ready to furnish bail and he does furnish bail, he will be released. Now, in illustration number 2, where he has caused an offense, where he has committed an offense where the punishment is for life imprisonment or 10 years or more imprisonment, then in that case the bail is not a matter of right, it is the matter of discretion of the court. The court decides, taking into so many factors, the bail chapter provides that he will be subject to the discretion. And it is not just the magistrate, but it's a session court, the court of session, the high court. All these powers, all these forums have power to entertain a bail application. Now, bail is something that happens after the person gets arrested, and there's also a bail chapter entirely dedicated to how and when bail is to be applied for and when it is granted. Now, a person gets, FIR gets registered, a person gets arrested, investigation is done, police files a report, charge sheet is done, or the final report is done, charge sheet leading to committal of the case, the magistrate taking cognizance, and then committal of the case, then case is going to court of session, hearing the parties, deciding that there is no offense they're committed and discharging it, or discharging the accused, or realizing that there is sufficient prima facie case made out here, that there has to be a trial, proceeds to frame charge, and the trial proceeds and it ends with either conviction or acquittal. Once the person is convicted and the judgment is drawn, that when the court delivers a judgment that the accused has been convicted, then followed with the hearing of the sentences, how much quantum of the sentence is to be given, awarded to the accused, what will be the fine amount if added, and these are the things which will be done after the judgment is out. After the judgment is out, the court hears the accused with regards to the quantum of punishment and award him accordingly. And that is the hope. And the judgment chapter, when we go through how the judgment is delivered after the trial, when the judgment is there is a particular chapter which dedicates to how the judgment is to be delivered, when to be delivered, by whom to be delivered, whether the accused person has to be there or not, what happens if specific certain exceptional circumstances come upon, then what will be the effect, what will be the effect on the judgment. These are the facts that are taken into consideration under the judgment chapter. Now, after the judgment is done, there is a scope of appeal. Appeal is a statutory right. A person doesn't have an inherent right that once the decision is out, he has a right to appeal. No. The statute provides whether a person has a right to appeal or not. It is subject to the statute, subject to the law. If the law provides us, he will. And in certain cases, if in this case, if he has the right to appeal, go for an appeal against the judgment or the sentence he has been awarded with, then he has the liberty to file it. And the execution of the sentence will not be until the appeal period has been lapsed, has been completed, or in case of where the appeal is filed, has been filed after the until the disposal of the appeal, the execution of the sentence will not be done. Now, this is what happened after the FIR was filed. Now the next question is, what happens if the criminal law, we remember, can be set in motion by two ways: by filing FIR, which I gave you an example that what happens after what, and we have come to a point where the accused is filing an appeal against the judgment which convicts him. Now, suppose the police officer, after listening to the informant, refuses to take the information and refuses to register an FIR. The informant has multiple options here, and in case if he fails to register, or if he refuses to register, although it's a dereliction of duty, but there are remedies. The police officer can make the informant can reduce the substance of information in writing and can by post send it to the superintendent of the police. That's one remedy. The other remedy is he can directly go to the magistrate and file a complaint, which 200 CRPC tells us the magistrate examines the witnesses and the complainant before him. And under the new law, we have realized that there's some changes done, which also says that before taking cognizance of the offence, the magistrate will have to listen to the accused of the offence. He will be also given an opportunity of being heard. That's the new law that says. Previously it was not present in the code. Now, once the once the complaint has been met, we have realized 190 also gives us a window that cognizance by the magistrate can also be done by a complaint. If any complaint is made to the magistrate has power to take cognizance of the offence. But now, what is FIR? What is complaint? Complaint is defined under the definition chapter section number 2. So complaint is an allegation made either orally or in writing to a magistrate, only with a view of taking action under the code against a person against whom the complaint or the allegation is made, whether the magistrate knows that person or not. But if he is realized that there is a offence committed, if there is an allegation, he takes cognizance of that complaint. And it is not necessary that he should know who has committed the offence. And it is the definition specifically says that complaint does not include a police report. So police report is completely different than a complaint. So now that these two things are completely separate, once a person files a complaint and court takes cognizance, and previously the law was, I am not certain whether the law is still the same, but previously I've learned that before taking cognizance of the offence, magistrate, when a complaint is filed to him, magistrate can direct for an investigation under 156 clause 3. Under 156 clause 3, once the investigation is directed, the magistrate, after taking cognizance, magistrate before taking pre-cognizance, at a pre-cognizance state, magistrate forwards directs the police officer to make an investigation and file a report. Once the report is filed, magistrate can take cognizance on the report as well. 190 provides for the similar thing. Now, once the complaint is made before the magistrate, there are so many things that could be done. One, the police officer can be directed under 156 clause 3 to investigate, and if the report is filed and magistrate feels like there is no sufficient ground to proceed, magistrate can drop the case. And if magistrate in that case there is no further proceeding is done in that case, and if the report discloses a cognizable offence, then the magistrate can take cognizance under section 190. If the report discloses no offence, magistrate even then can take cognizance of the final report. And if nothing happens, the magistrate can take cognizance on the complaint made to him directly. So there are options. It is not a black and white situation. There's so many options. There's so many bifurcations. There's so many means to reach out to a solution. Though it is not constrained, either it will happen A or B. It's not like that. When a complaint is made before a magistrate, there are multiple options magistrate has, and in order to ascertain whether there is the sufficient facts and circumstances of the case is so sufficient to proceed against a person, these are the parameters the magistrate takes into account only because to ascertain that there is actually a case. And not everyone should come up to the magistrate and file any kind of report and any kind of complaint, and it becomes mandatory for the magistrate to arrest a person or follow and sue him under any legal procedure. It is not like that. The intention behind these scrutiny, these checks and balance in these things, that these parameters, is to assure that a innocent person, a normal person who has got nothing to do with the crime or any kind of offense, should not get heckled by law. Because once the criminal law gets in motion, it has to have a conclusion. It cannot be left in between. So the procedure of filing a complaint, also CRPC provides how and when a person can file a complaint before a magistrate. Once a complaint is filed before a magistrate, in order to ensure there's sufficient ground to proceed or not, and can direct the police officer to investigate only to ascertain that there is sufficient ground to proceed or not. It is not as a regular direction to investigate the case. There is a difference between investigation directed under section 156 clause 3 and direction of investigation by the magistrate under section 202 of CRPC. Under 202 CRPC, the purpose of direction of investigation, which he could inquire by himself also, the provision also says that magistrate either inquires the matter himself to ascertain there is sufficient ground or not. If he fails to do that, he can also direct the police officer to do that with this regard. Only the purpose is to ascertain, yes, sufficient ground to proceed against the person. And there's a list of provisions following one after the other as to how the proceeding ensues later. And this is also one of the means we can set the criminal law in motion. Now, CRPC, after we have understood that how offense once done can come to the knowledge of police officer, he files an FIR and the process ensued, as I mentioned, and also there's another option of filing a complaint before a magistrate, and he takes cognizance of the case and he continues with the case and issues process against the person. Either if the case could be either a summons case where the amount of punishment could be awarded is less, or a warrant case where the offense is accused with is punishable with death, imprisonment for life, or 2 years or more punishment. So in those cases, the approach, the law, the procedure is entirely different. We have to also take into consideration as to uh, when police officer has to act upon the FIR, what will be the repercussions, and of not registering an FIR. So CRPC, if I come to a conclusion, when I look into this whole scenario, I realize CRPC, if a person studying CRPC understands what comes after the other, he will also get an idea that only by going through the content chapter, you will realize that the things I mentioned is exactly positioned one after the other. There's certain exception, like the bail is the last part of the code. So there are certain things that comes into the scenarios systematically, as I mentioned. And there are other important provisions which, although I did not mention, is there in CRPC, and which not just accentuates but highlights these main provisions. There are certain provisions like investigations, the most integral part of the CRPC: investigation, trial, appreciation, how evidence is to be appreciated, who is supposed to give evidence, when an accused person can also be asked to depose evidence by the court, and what are the general provisions that enhances the whole important parts of these important parts of the CRPC. The CRPC is all about these things. It deals with the procedural part as well. As I always also mentioned earlier, CRPC is also it's a mixture of adjective and subjective law. CRPC also deals with the rights of the parties. That comes to my mind right now is the maintenance proceedings. Supposedly, a person can apply under CRPC law. It's a secular form of law, we can say. Any person of any religion, of any race, can come and file a petition under 125 CRPC, praying that he the person is entitled to maintenance, but the person who's supposed to maintain him is refusing or neglecting him to maintain. So magistrate of first class can take the matter into consideration and make orders accordingly. So deciding rights of a person is also it also has its own place in CRPC. So it's not just an objective law. Now, can we say that once the CRPC has been repealed and the BNSS of Bharatiya Nagarik Suraksha Sanhita has come into effect, can we say that all the proceedings that was continuing according to CRPC has been stalled and has been again replaced by BNSS? No. The For every act or every enactment passed by the parliament, they always have a saving clause, a repeal clause, which directs us, which tells us what will be the future of the code or the act, what will be the effect or the effect of the new act subject to the code that has been already repealed. So in accordance to that, CRPC that has been applied to any law will continue like that. Any offence that has been committed, we can understand it like that. Any offence committed after 1st July 2024, when BNSS, the Adhiniyam, the Evidence Act got repealed. These laws when came into effect, after that any offence committed will be subject to this. Otherwise, the offences which has been continued, which has been tried, which has been when the proceedings has been begun, the law has set in motion for those offences, they will be subject to CRPC. Now, the most important part of the CRPC, I'll tell you, it will be my concluding provision. As we have seen in Civil Procedure Code, in criminal procedure, there is always High Court. There is always a provision in which High Court has inherent power to pass any law in order to give effect of any law, to pass any order, to give effect to any law, to give effect to any order passed under this code, and to prevent the abuse of the process of law, and to protect the ends of the justice. And in that case, High Court has inherent power, and under CRPC it is 482. CRPC 482 is contemporary with 528 of BNSS, I guess, and that is the provision which allows, as I said, which gives a window to High Court to pass any order, to give effect to any order passed under this code, to protect the ends of the justice, to prevent the abuse of the law. And but this provision comes into play when there is no specific rule, when there is no specific provision or the law to be taken into consideration with a particular matter of fact. Supposedly, a person in this case, suppose a person who has been in the illustration I mentioned, suppose A. A has been falsely accused of something. That person C, out of out of prejudice, out of hatred towards A, went to the police and said certain things has happened. And after investigation, police had an impression that this certain things have happened, which led to A's arrest, filing of FIR, and forwarding him to the magistrate and arresting him, and all these things I have mentioned earlier has happened. And but the truth of the matter is, A had got nothing to do with it. In that case, what happens? High Court has power to quash the FIR, on the grounds to protect the ends of the justice and to prevent the abuse of the law. Because he has been falsely accused and he'll be heckled by the lengthier legal process, High Court, the Code of Criminal Procedure, the BNSS, has an inherent power, provides the High Court with an inherent power to protect the ends of justice. In that case, High Court has power to proceed to quash the FIR. And not just FIR, the book prescribes us with multiple illustration as to what all things that comes within the ambit of 482. It's really vast. The only thing that is to be taken into consideration, 482 comes into place when there is no specific provision. When there is no specific provision to deal with the specific condition, situation at hand. In that case, 482 comes into play. So this was all in all about the Code of Criminal Procedure, Bharatiya Nagarik Suraksha Samhita. I have given a brief introduction. I have tried to touch all the relevant provisions of the code, and although I don't have specific, I don't remember the specific provisions of the BNSS, but I'm trying to have just started to going through the provisions and the changes that has been brought about. And so mentioning, I have touched all the important provisions and the manner how Code of Criminal Procedure comes into play, and that will be all from my side. And